I didn't ask her to. She's free.
Oh, whoa. Is that what happened? I don't know that there's a good answer, but you better be careful how you answer it because I don't know which is worse. You telling me that yes, is that what I did, or you lying to
At this time, Your Honor, I'm asking if the court would convert her to a scram tether and mandate that
me? She drank and then had a child blow into the sober lane.
Judge Simpson presides over the case of People versus Ashley Treat, where the defendant is accused of violating the conditions of her bond by consuming alcohol and, more seriously, having her 13-year-old child blow into a SoberLink breathalyzer device in an attempt to falsify a test result. During the hearing, the defense presents a recovery plan that includes intensive outpatient treatment, arguing that she should be given another opportunity to address her substance abuse issues. The prosecution, however, emphasizes the seriousness of the violations, pointing to her extremely high blood alcohol concentration of 0.258 at the time of her arrest and the deliberate manipulation of the monitoring device.
And Laura Yaki, Assistant Public Defender, with and on behalf of Ms. Threet, who's approaching. Ms. Threet, could you state your name for the court?
Bachelor Threet.
So, Your Honor, within the last couple days, Ms. Threet has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. Again, I have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning, is very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her SoberLink to a scram tether to ensure that she's getting 24/7 supervision monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
Yes, Your Honor. There's no minimizing, there's no excuse or justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses. So she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe. And
So even worse, she had a 13-year-old blow into the machine?
Well,
I didn't ask her to. She's free.
Oh, whoa. Is that what happened?
I didn't.
Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it because I don't know which is worse. You telling me that yes, is that what I did, or you lying to me?
At this time, Your Honor, I'm asking if the court would convert her to a scram tether and mandate that she
drank and then had a child blow into the sober lane.
I understand that's what the violation report says, Your Honor. And
does she admit to that violation or not? I mean, if she wants a hearing, we'll have a hearing.
I understand. May I have a moment to verify with her, Your Honor?
Yep.
Your Honor, may we briefly approach?
I don't know what good it's going to do, but you can come on. Record should reflect we've had a bench conference in this case. You're supposed to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the bench conference is if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient treatment program with a tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left a an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged offense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case just held in jail without the opportunity to get inpatient treatment.
Ms. Feltes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is an operating while intoxicated third offense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers crashed. And when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that sober link. I do not think she is in a position where she's capable of making good decisions. And I do not think that she is a risk the community can tolerate. I'm asking both the bond, hold her without bond, deny her a release.
Anything else, Ms. Conley?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a scram, if she's in treatment, especially if she can't leave.
I can't trust her. I'm just gonna be upfront. It is going to be very hard for me to trust somebody that this court releases on a sober link, can't comply with the sober link, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference May 14, 2026, 9 a.m. I'll also adjourn, since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the Washington County Jail.
After hearing both sides, Judge Simpson strongly condemns Ashley Treat's actions, expressing particular concern over her decision to involve her child in the deception. Stating that the court has completely lost trust in the defendant, Judge Simpson revokes her bond, orders her remanded to the Washtenaw County Jail, and schedules a bond violation hearing for May 14, 2026. What do you think? Did Judge Simpson make the right decision? Share your thoughts in the comments below. If you enjoy real courtroom drama, shocking judge moments, and high-stakes legal cases, make sure to subscribe to the channel and turn on notifications so you never miss an upload. Click on the next video to watch another unbelievable courtroom confrontation that you won't want to miss.